Justice cannot be for one side alone, but must be for both. Eleanor Roosevelt.
The lack of representation due to someone's income causes a cycle of poverty that is due to the two justice systems that are unjust. Therefore, we propose that public defenders should be used in a different way. A public attorney is appointed to someone that cannot afford one. As for a private attorney, is paid by the defendant that can afford it. Knowing the importance of the difference is pivotal to our strong topic of the financial effects in the justice system. We are exposing the downfalls of the system that is organized as if no money equals no defense, which enforces no freedom.
The importance of representation allows people to make the appropriate decision about whether or not to fight their cases. Legal representation is essential in certain aspects of life, especially when faced with a legal dilemma. A prime example of why representation is major for defendants is the heavily burdened lawyers in Oregon justice system.
For years, state leaders have known Oregon's public defense system was overburdened. But the pandemic made things worse. Courts slowed. That left many public defenders with caseloads so high, some say they cannot ethically take on more clients.
Knowing about Oregon's justice system makes you wonder about justice systems around the U.S. According to the U.S. Department of Justice, public attorneys have a higher conviction rate for their defendants by 12% compared to private. The court reasoned that the right to counsel was fundamental. The court continued, in our system of justice, any person too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. Lawyers in criminal courts are necessities, not luxuries. This conclusion was only thought of after the Gideon v. Wainwright, which was a landmark U.S. Supreme Court decision in which the court ruled that the Sixth Amendment of the U.S. Constitution requires U.S. states to provide attorneys to criminal defendants who are unable to afford their own. But a half-century after Gideon v. Wainwright, many lawyers say the system for providing defense attorneys for the poor is in crisis. One of those lawyers is Norman Lefstein, who started working for the poor criminal defendants in Washington, D.C., a few months after the Gideon ruling on March 18, 1963.
It is a vital constitutional right. It distinguishes us as a country. I happen to believe that the quality of justice in our courts says a lot about the kind of society we are.
Lefstein devoted his career to the idea that people facing jail or prison time need lawyers. But he's troubled by what he sees and hears today.
When he brings up the quality of the U.S. justice system, he's referring to the fact that having equal justice for the poor is often money, or the lack of it can be the deciding factor in the courtroom. Just because we provide attorneys for defendants doesn't mean they have the resources and time to be invested in the defendants' cases. Lefstein turned to a defense lawyer for poor people in a northeastern state.
In my judgment, his caseload was absurd. I mean, just try to imagine simultaneously representing competently over 300 clients. And he was in an impossible situation.
Those caseloads are impossible for one person to handle, which defeats the purpose of how helpful public attorneys could be. At the federal level of our research highlighted many points of no money equals no freedom.